This is a haiku from Kobayashi Isa. And for me, it is a common question to have the one about hope. Where do I find my hope? Or how can we continue with this work even when we are facing so many problems, so many setbacks? And I have to assume that an important part of this question is because I'm very critical about how things are working or not working. And I really don't like to pretend that I'm more optimistic than I really am. The idea of having this strategic optimism, it's not something that I like. It doesn't sound particularly attractive to me, so I don't have it. And no, I'm not an optimistic. But I don't think things are going to work out in the end just because. I do have hope, which is something different than being optimistic. I have the active feeling of hope, which means I do believe that we can work for a better future and change things, but that takes effort, that takes determination, and the reasonable expectation of not being alive to see the results. And this is a problem maybe, but it's something beautiful, I think. In the effort to think about these words and hope in general, I ran into a beautiful book called Hope Without Optimism, which is a book from the British thinker Terry Eggleton. And one of the things that he says is this one. I quote, "To have faith in the human passion for justice, for example, to which the whole of history bears witness, is to have a reasonable hope that it will not vanish from the earth without a struggle, even if it does not finally prevail. Hope is one species of what Aristotle calls rational desire, as opposed to the kind of desire that, like wanting to eat or sleep, is simply a matter of appetite. Hope, then, is a more positive disposition than desire. The latter tends to revolve around a sense of lack, while the former mixes the disquiet with a degree of tense expectancy." And John Stuart Mill, about hope, he sees hope as a virtue, and he says, it's a disposition that gives a spur to the faculties and keep all the active energies in good working order. Finally, the last quote is from Descartes, who views hope as a disposition of the soul to be convinced that what one desires will come about. Is the snail climbing the Mount Fuji an example of hope? This is a question that I have, no? And in a sense, for me, it is. Not for all Japanese interpreters of the haiku, this is hope, but for me, it is. The haiku does not pretend that the snail is going to reach the top of the mountain, but it repeats slowly, slowly. Not asking to the snail to be slow, to reduce the speed, but rather observing the scene and the movement, which is very, very slow. I hope climate justice will not be that slow, for sure. But slowness is also part of the nature of the snail. If she is climbing Mount Fuji, it will be slowly. And that is not only okay, but it is the only way it can happen. Trusting her movements, continuing her path. It takes hopes, but also it takes trust. And my hope and my trust nowadays wrap around justice. I don't know if just nowadays, but they wrap around justice. Not thinking that justice will deliver, or that this particular court, in the sense that we're having the hearing now, this particular court will bring justice, but about the reasonable hope that there will be a struggle to achieve justice in any future scenario. If we are moving to green capitalism, or we move to something better, we will be fighting for justice anyway. A struggle in which each of us will have our own Mount Fuji to climb, and our own personal struggle to understand that we may not reach the top, but our work will contribute to others reaching it. Our own demand for justice is, after all, a demand for a new way to understand community, a community that includes everyone and considers the relative position and capabilities amid the climate crisis. A community that includes other forms of life different from humans. A community that includes future generations. Demanding this kind of justice is, after all, intrinsically an ongoing process. We will always be demanding that justice, and we will never see the results. Therefore, as with what happens with the snail, our hope cannot be attached to reaching the top, but instead it has to be connected with the effort, with the struggle, with our own Mount Fuji, and the fact that maybe those who come after us will start not from the bottom of the mountain, but a little bit further up. And there is a piece here in the haiku that is missing for me. Climbing by ourselves is not as significant as climbing alongside others who share our values, hopes, and fears. I will say that the only sustainable way to continue climbing is the mix between hope and company. The consciousness of being part of a movement, of an intergenerational collectivity of people forming a chain of which each one of us is a part, just a part. I'm sure this is something that moves the authors, that moves our presentators as well. The idea that we can have hope and community. This book aims to be part of that chain. The book we are presenting today is the result of the work of many, many people. The authors, of course, are Litigate, José Daniel Rodríguez, Alana Lancaster, Nomasango Masille Moyo, Nomakashi Masille Moyo, Jorge Piñera, Anthony Abad, María Valeria Berros, Macarena Martinich, Marisol Angles, Marie-Claire Cordoner, Thalsa Tisiri Macauche, Sunaide Musa Guadiwala, Tejas Rao, Hugh Travis, Susana Borras, and Silvia Bañi. And also the work from the co-director of the book, Pilar Moraga, the Professor Pilar Moraga, the style editor, led by Felipe Morales, File Foundation that I already said, NGO FIMA, University of Chile, and Catalina Santeliz is here, that she was the one coordinating everything, basically. All that we have here is because of her. So my deepest gratitude for all the work that all these people has done, but also for all the work that you are doing, that we are doing, that our presentators are doing. And we have with us today to present the book, Margareta Werrinkel. She's a lecturer in environmental law at the University of South Pacific and one of the minds behind this strategy. We have, and she will be the first talking because she has to leave. And we have Marcelo Cohen, who is a professor of international law at the Graduate Institute of International and Development Studies in Geneva. Emeritus. And he was representing today Costa Rica at the hearing. And we have Christine Kasper, who is the General Counsel of Greenpeace International. Many thanks for being here. Margarita, you have the floor.
Thank you so much, Casio. And first of all, warmest congratulations to all of you who have contributed to this fantastic book. I have not yet read it, but I feel certain that it is already an incredible resource. I do not know to what extent it has already been relied upon by participants in these proceedings, but I would not be surprised if it has already been utilized, and we'll see some matches between the content of the book and submissions that have been made. But in any event, it's also an example of how a legal process like this can generate and can inspire, can generate collaboration, stimulate scholarship, exchange, in a way that makes this whole process be much more than just the application of the law to the facts by this particular very important judicial body. So very much looking forward to reading the book. And while we're at it, I'm sure that many of us here present in this room today will have contributed one way or another to this initiative, probably already from an early stage for many of us, maybe prior to its the resolution 77/276 being adopted by the UN General Assembly, and after, in some way either directly through engagement with participants in the proceedings, or with judges or legal officers working at the court or others, or in a kind of broader ecosystem of discourse, activism, lawyering around this initiative. So deepest thanks, because it is only through our collective efforts that we are going to hopefully secure a good outcome, but also make sure that that outcome is not going to be a dead letter, but that it's actually going to bring us closer to justice. Now, let me start with something a little different, perhaps. So I guess, especially for those of us who work with the law, we're very used to working with facts, with science, and with legal norms, rules, principles. So I'm also a person who spends too much time in that sphere, and to balance that out a little bit, I have some habits. Could dwell on that for some time, but one of those is I like to draw tarot cards every now and then, to especially significant points in time. So as we were looking forward to the proceedings, I thought to draw cards excitedly, with anticipation. What would the deck tell me? It's usually quite spot on. So I thought it's going to be maybe justice, the world, sun, the moon, maybe star, or one of the aces, or swords. Okay, what did I get? You got it? You see, it's more, it's not just random, right? So, I don't know, do you feel what I feel? Like, your heart does sink a little, right? Okay, all right. So I don't challenge the deck. I don't draw another card. Okay. Well, let's just take some time to process it. But now, so 3 days ago, I drew a card, and now it makes so much sense to me after a couple of days and having seen some of the drama play out, the court. It's about the death of the system. That's what we're doing. We're finally trying to be radical. We say it's over. Enough is enough. So cessation, that is right. So no more destruction of the climate system. No more violations. Christ, there's no excuse. Carbon budget, fair enough. But if you've exploited more than what anyway, this whole notion, we should have a separate session on it, probably, the notion of a carbon budget, right? Because in the end, it is simply about causing harm, and how much harm, are you entitled to cause? Probably not that much, and certainly not if you really are causing harm to the very foundations of life, if people's livelihoods are affected, and if then these fundamental rights, norms that we have said we care about, that we have said we would respect, that come into play, and then in order to show that these non-agreements actually matter in the real world, that our commitment is genuine, we must then also adjust our actions. And so it's gone way out of hand, right? This whole problem. Now we see the big polluters hiding behind the Paris Agreement and the Climate Convention, that the argument that this is where we do climate action would be much more plausible if that would indeed also happen in that sphere, and if those that regime would also actually deliver the emission reductions that are necessary to achieve the very objective of the climate convention. And so that whole argument lacks credibility when it's made by actors who do the opposite of what they have pledged to do under these very instruments. So I've really started to now embrace this debt card, because it's no less than that. The whole system, as it has grown, as it has shaped, is now unfortunately facilitating destruction, and so it is really dismantling the system that is needed. And it's not an abstract notion of an activist slogan, but it's also a notion that lawyers can work with, because this system is made up also to a very large extent of law. So we're talking about investment law, for example, which is really, and here we have, of course, former Special Rapporteur David Boyd, who wrote an entire report on this question of how these structures, these legal structures, actually facilitate destruction. And so it's time to then look at the norms that can be used to destroy those structures, and they're very useful parts of international law. So we hear arguments being made about jus cogens. If you get into that sphere, then already you have quite powerful tools when it comes to treaties, for example, that violate such norms. So the court is being encouraged to go there. I think that it's very encouraging to see also a number of submissions that go in this direction. So I'm very hopeful that this is actually where we're going, and I'm excited about the energy that there is, and the willingness to embrace this very radical idea that enough is enough, and we are prepared to really achieve collectively a type of transformation that has probably not occurred before in human history. Of course, there has been, in terms of international law, the formation of states, decolonization, etc. Now we are in this still kind of Westphalian order that if you look back, has to a large extent also facilitated extraction of nature of peoples, and those who have been subjected to that, to atrocities, extraction, etc., have so far not really risen up, certainly not overhauled the system. So maybe this is where the point in time where we have arrived, where the vast majority of people are done with it, and now challenging the system by invoking the norms that are actually most foundational. And we hope that the court will also recognize that. But in any event, I think the energy is there. So even whatever the outcome of the opinion, we hope it's going to be strong, positive. But regardless, I think the energy is there, and we're not going to give up until it's done. And that will never get there, of course. It's just like the snail, but at least this is where we're going.
Bravo.
So thank you.
Thank you very much for that. You have to leave. Thank you. Before passing the microphone to Marcelo, I would like to remind you that there are some keychains in the table there, and I advise you to take one keychain, not because it's a good gift only, but because also they have surprises. So. Okay. So, Marcel, the floor is yours.
Thank you. Well, thank you very much. First of all, I would like to thank FIMA and the Facultad de Derecho de la Universidad de Chile for giving me the opportunity to meet young people who give hope. As someone who started his political life very young under one of the dictatorship that we suffered in South America, I'm very happy to see that young people are committed to the idea of justice and they continue the struggle that we started many decades ago. And so I'm very happy for that. And I really appreciate a lot this opportunity because it gives hope. Well, Ezio made a kind of distinction. I have also read this distinction between hope and optimism. I think it is important to keep both, indeed, because, well, the opposite of optimism is what? Pessimism. So, and I always thought during the darkest times, during the dictatorship, I always imagined myself in Europe in 1941, and I said, well, what would have been your attitude or your position? It would have been difficult to be optimistic in Europe in 1941, I think. But after all, 1945 came. So that's important. Hope and everything you said, I entirely agree with this. But it is also important to keep optimism. The one who is telling you this is someone who sometimes feels the opposite. So that's the reason why I suggest you to use hope and to keep optimism. This is one important message, yes, probably. Well, I have the possibility to have a look, a serious look, to the book, but I have to say I received the PDF last week. So it was a serious look, but obviously I didn't read from the first to the last page of the book. So, but what I will stay with criticism. But it's a very nice criticism. Because indeed the title of this book doesn't really say what exactly it contains. It contains more than that. That's the point. Because you have a look at the title and then you think immediately state responsibility. Although it is in plural, responsibilities. But the idea for people doing international law, when you just hear the word responsibility, you immediately think about responsibility for wrongful acts, maybe also liability for acts that are not prohibited in international law. But this book goes beyond, because it explains the different aspects of the applicable law to the problem of climate change. It's not just only a state responsibility. And then, one important point I also realized when I looked at it was it has the very last information concerning case law, and it's very useful. So it's very important that you have published the book now. It would have been better earlier. but it is also very important that you had the idea to launch the book here and now.
Yes.
Because we are just at the beginning of the oral hearings, and you have been following, all of you, I'm sure. We have just 3 days, and in 3 days we listen many different things. So those who are really willing to have the ICJ going ahead and ascertaining that according to international law as it is today, so there are responsibilities. So those who are the principal polluters must pay, to say it quickly. But we also hear the traditional positions of those who are the principal responsible of the situation trying to escape from their real obligations and their responsibilities. And this is, to some extent, I felt shame even listening to some of their arguments. And this is the reason why this morning I added a phrase which was not written in my speech when I mentioned this idea that human rights, well, only states are obliged to respect them within their territory or on the areas under jurisdiction or control of the states. That's amazing. It's a total regression from what we have obtained many decades ago. Because what is the idea? Does it mean that states can violate human rights if the victims are outside their jurisdiction? That's amazing. So the fact that they had to use these kind of arguments, the idea of lex specialis, well, one can understand this effort, which is wrong. But yes, because it is not only legally, but it's logically wrong. Because someone said so on Monday, I think, I don't remember which state, but someone said, so that it's amazing. So it would have been better not to have the UNFCCC or the Paris Agreement, because that without them, international law would be more efficient and more and requiring more to states than the fact the states have adopted treaties. So they lower their obligations by concluding the UNFCCC or the Paris Agreement. It's completely absurd. So the same ideas. But this is not new. This is my fourth advisory opinion in which I participated. I have to say, in two I was happy of the outcome. In one I was not. I hope that I will be 3-1. And I think it all depends also on what we are doing now, and what those who still have the opportunity to speak this week and next week to go ahead with probably different perspectives, adding new arguments, or not. There is a point which what I mentioned today is something, and some people say, why you distinguish due diligence, the obligation of prevention and the obligation not to cause significant environmental transboundary harm? Why you make this triple distinction? And I believe that this is very important, because what they are doing, the opposite side, is to embark us on a discussion about obligations of efforts or obligations of result. Yes. And that's not the point, because due diligence due diligence is applicable for all obligations of international law. It's not something specific for environmental law. Due diligence, for instance, a state has to apply due diligence in the protection of the diplomatic premises of other states. Due diligence. The obligation of prevention, yeah, it also applies in different areas. But the point is, because one state can say, well, I did my best, but I caused harm, but I did my best, so I'm not responsible for that because I did my best. So it is very important, and if you have the opportunity to mention to those who will speak still this week or next week, please insist on this, because it's very important. So if someone has caused transboundary harm, then there is a breach. It's not a matter of, well, due diligence, everything together. No. So there are 3 different obligations. And this is very important because due diligence is indeed an obligation of best efforts. It's normal. It is true. This is not the whole picture. So the whole picture is they are causing significant transboundary harm. They are polluting the planet, and this is the breach, not just the question of due diligence or not. This is a very important point I would like to mention. Yes, I said that I'm very happy because I see young people here fighting, but I also have to apologize because, or not, because I was invited to attend one of the conferences in Santiago de Chile in May, and I decided not to go. Why? For obvious reasons. So I live in Geneva. I was allocated 15 minutes, and I said, come on, I will speak about climate change, and I will take a flight from Geneva to Santiago to speak 15 minutes. No. I did it on Zoom, and at least I made a modest contribution, but I took into account the cause for which we are fighting. That was the reason why I didn't participate in person, but I did it online. Okay, so I think I have to stop here. And yes. Since I gave my speech in French, probably the temptation would be to repeat it in English. 20 minutes.
It would be really great if someone gave me like a 5-minute and then a 10-minute, just to make sure it stays within. Yeah, great, thank you. So I first wanted to say thank you for the massive effort that went into this book. It is not easy to do this, and I understand that you pulled it off in a short period of time with the best brains from around the world, a really diverse array of authors, and I would like, maybe it's a little bit of a contradiction to what you said, I think it came out at the best time possible. It comes out right as we're sitting here in The Hague during the hearings, and there's a period of time that I've heard from experts between now and when the advisory opinion is issued that is key to the outcome. So I hope that every judge has this book in their hand, that every lawyer who will be responding to questions in the coming days will have the book in hand. I think it is a very powerful tool to inform the end result that we want and hope to see. So, and I completely just want to throw out my notes because I just want to respond to everything, but I'm going to respond to the question about pessimism, optimism, and hope. I am optimistic to my fault, and I have to be, but I want to discuss more the difference between optimism and hope. But in order to be optimistic and to have hope, I think you need to be able to take action. And what I love seeing in this room is a group of people who take action. And so I want my remarks on the book to really get concrete about the action that is happening in the world. And I wish I could have every single one, and especially my team members up here speaking, because they're the ones every single day putting hope into action to get a result. And I think that we're going to get there, even though some of the presentations here in The Hague have been maybe a little bit pessimistic, but I think we're still going to get there. So 4 remarks that I hope to make tonight is 1, we've come a long way, and I'll explain that in a minute. The second one is that the advisory opinion processes here, the ICJ, the Inter-American Court of Human Rights, and ITLOS, and all these advisory opinion processes are important, not because of just what the science and the law that are happening, but it's the facts. And more importantly, ever before, I've seen the lived experiences of communities being put here in this space and discussed. And we'll go into that a little bit more, but I think we're transparent. We really are taking a very radical approach to the law and making sure that the community's voices are being heard by the power holders. And then the last point is we need to be prepared, people. The backlash is here, it's coming. The more successful that we are in courts, the more the backlash is happening. And this book took that issue on, and I'm so grateful for that. So thanks. So the first question, we've come a long way. 14 years ago, I'm feeling old, one of the first books on climate change liability came out. It was called, I think it was called Climate Liability, Transnational Law and Practice, another book that needed a different title. So this book was produced and edited by Richard Lord, and I wish he was in the room today, but it was a really interesting book, and it inspired so many legal actions around the world. It was a comparative book. It was meant to be independent. It looked at 17 jurisdictions. It was really, really interesting, and I think what's funny is that hot case in that book at the time was this US case called Massachusetts v. EPA. I mean, think about it. For all of you climate law geeks, Massachusetts v. EPA was like the leading case at the time. And look at how far we are. How many cases are there, climate cases around the world? Hundreds. So much has changed. And at the time of that book launch, it was in South Africa, one of the book launch times that was in 2011, yes. And Kumi Naidoo, who was then the executive director of Greenpeace International, we got him to go to the book launch and help with it. And of course, we write talking points for our executive directors. And I found the old talking points, and this is what he said.
Oh my God.
Whilst a negotiated, fair, ambitious, and binding climate agreement remains preferable, inaction on the political front will inevitably lead to action on the legal front. In September, and he meant September 2011, Palau and another Pacific Island nation announced it would seek an advisory opinion from the International Court of Justice on the state responsibility for climate change. I hope this inspires other countries and communities impacted by climate change to follow the steps of Micronesia and Palau and take their fate in their own hands. With this book, they know they have the law on their side. Yeah. But there was something very much missing in the book and outside of the book. So the book was missing analysis of international legal options. It just didn't. I mean, I think whenever you write a book, you have to narrow the scope. So it's not a critique, it's just, it didn't have that. Also at the time, what was missing was the voice of communities and the power of the movement and the people power. And that is why we are here today. And it's because in 2019, a group of students at the University of South Pacific got together and formed an organization to make a campaign to call for an International Court of Justice advisory opinion. I mean, so let's clap to those. Then this movement grew, spread across the world. You saw the development of the World Youth for Climate Justice. You saw a non-governmental organization alliance. I think I'm sorry if I'm getting this right, Katrina Bullock from Greenpeace Australia Pacific was there, but the Alliance for a Climate Justice Advisory Opinion grew, and then there was the Friends of the Initiative, there was like the academics, the researchers, and then you had Vanuatu, a brave country that took it on And they led this coalition of 132 nations that signed, that pushed through the resolution. And I wish Margareta was here because I wanted to do this for her. I just think that we need to applaud Vanuatu and Blue Ocean Law and those who are behind it that made a lot of this work happen. So let's just take a moment there and applaud Blue Ocean Law. So now to the book. The first chapter of the book, which I loved, had two authors on it, Aditi and Jose Daniel Rodriguez. And, these are two scholars that come from the World Youth for Climate Justice. I think that symbolism of having them be the first authors in the first chapter says so much about what is different today versus 2011. So now into my second reflection. Do I still have time? I'm okay? Okay. Second reflection. The advisory opinion proceedings before the Inter-American Court of Human Rights, the International Tribunal for the Law of the Sea, and the ICJ are being powerfully shaped by the lived experiences of communities and their views of justice and injustice. So in the introduction of the book, and I did read as much as I possibly could, in the introduction of the book, as you and Pilar say, the basic notion of climate justice demands to understand that while the impacts of climate change are global, they are not felt equally. Vulnerable communities, often those least responsible for greenhouse gas emissions, are bearing the worst effects. So it's all about the communities and those who are being most impacted. That's why this is a climate justice advisory opinion process. The advisory opinion at the different levels in different courts and different bodies are different, but we're seeing the power of these voices. So I have a question in this room, and it's a little bit of an interactive question. Is that okay? Okay. Raise your hand if you attended the People's Assembly. Whoa, okay. I'm gonna ask two people to say their reflections. What was important about this People's Assembly for the ICJ proceeding? And so why do you think the People's Assembly is important for the official proceedings that are happening? Anyone want to try to answer? Okay, I got two hands, and we're just going to do this quickly. Nick, Lynn?
Because the judges need to be aware of the impact of the crisis, and that's one way of delivering that message forcefully into the courtroom.
Excellent. Do you want to pass it on to...
I would say it's because civil society has not been allowed to speak directly to the judges. And we have to get those stories to them in some way. So if they won't hear civil society, we're going to speak anyway.
Yes, that's right. Anyone else want to say anything? No? Oh, there you go.
Unfortunately, many of the nation states that have made submissions to the court don't necessarily represent the views of those most impacted by climate change within their territories. So we saw a number of regressive submissions from the USA today, which is completely at odds with the climate impacted communities across the USA that are struggling to deal with this issue. So having something like the People's Assembly, where we get the voices of those most impacted, and we have wonderful panelists like David Boyd and scholars that are putting together the reports so that it can actually be tendered to the court and heard in those proceedings, is such an incredibly opportunity to have community representation in a way that's not currently built into the processes.
Okay, these are great answers, and I think it's all of the above, right? That's why that People's Assembly. And so if you have not gone, go tomorrow. Make it your top priority. It's incredible, actually. It's a really incredible moment. So the reason why I also think it's important is question 2B of the ICJ advisory opinion, which says, what are the legal consequences of states where they, by their acts or omissions, have caused significant harm to the climate system and other parts of the environment with respect to peoples and individuals of the present and future generations affected by the adverse effects of climate change? I mean, the question itself is about peoples. It's incredible. Okay, but I want to talk a little bit about how community voices are coming out. And I'm going to now look to two of my colleagues in this room that have been working on the Inter-American Court of Human Rights. And feel free to come in, but you can in questions or whatever here. So the Inter-American Court of Human Rights had held hearings in April and May on the obligations of states in the climate emergency. And these hearings featured the community of El Bosque. And this is the first community in Mexico that I understand has been officially recognized as internally displaced. By climate change, thank you. Important, by climate change. And Greenpeace and others worked with these communities and they made a submission, and there was one particular part of the testimony I just want to read out by a community member, it's Guadalupe Cabos Pacheco said this. So, and she wrote, "Climate change has caused a radical change in our lives, slowly but surely. Today, we are not the same as we were yesterday, when we had Christmas, celebrations, posadas. It has changed us in every way, in our work, in everything. And today, I can ask that this very difficult change has been very, very hard and painful." That's an important testimony. And that's before the Inter-American Court. And then in the International Court of Justice, there's also been community voices. So not directly, but I think that Julian Aguan of Blue Ocean Law and his concluding paragraph on Monday was one of the most powerful paragraphs, powerful oral statements that we've heard. And I'm only going to read part of what he wrote. But he said, "In closing, throughout these proceedings, we have taken great care to accurately describe the peoples and cultures of Melanesia, even though we are aware that most aspects of those same cultures are difficult to translate into any language officially recognized by this court. But we've done so because, as surely as these peoples deserve to live in the world on their own terms, so too do they deserve to be heard here." So powerful, very powerful. So I think that the book in itself, while it's a legal, technical one, also imbues the community voices and how important it is to achieving that justice. So I really thought that was excellent to see, because you don't see that in most books, and surely that was not in that 2011 book as much as it is here. So thank you. Third, final, well, I don't know how much time I have, but I'm just going to keep going.
Just keep going.
Keep going? Okay. So last reflection is I was excited that the historic case, the Klima Signorinen case, the judgment before the European Court of Human Rights was mentioned not only in the opening presentation by Margareta, but it's been mentioned throughout the hearings. And so that I think it's really important, because while this is the International Court of Justice, we see it that the importance of the regional courts and domestic courts in these hearings. And I think it's really important for us to just kind of reflect on what that case was, and that Margareta pointed out in her presentation, and she would probably say in a different way, but the UNFCCC, the idea that the UNFCCC replaces international rules is wrong. She said something like that. And she pointed out really clearly that the European Court of Human Rights judgment in the Klima Signorinen expressly relies on Article 47 of the ILC articles, and states that can be held internationally responsible for violations stemming from their contributions to climate change. So this is huge, and she brought it in the court, and I think, I'm not sure how many people in this room, in fact, I think all of the people in this room probably know about the Klima Signorinen decision, and there's a person hiding behind there, that's Valentina, who knows a lot about this decision. But I'm just going to point out a little bit of the facts of that case, because I think we should be using it as much as possible in the hearings, and both at the ICJ and elsewhere. But the Klima Signorinen decision the journey started way back in 2016. So this is a snail going up a hill. A group was founded, an association, Swiss Climate Senior Women. It started with just a handful of people, and is now 3,400 individuals part of that association. Massive. They lost and lost and lost through the entire domestic system, till they eventually decided, let's bring an application to the European Court of Human Rights. They brought it in 2020. And they told the court last March, and this is a quote, "The entitlement of individuals to be free from acts that cause their premature death, as well as to enjoy a life with dignity." That's what they were seeking, so important. So I just think dignity is a huge part of also being able to have hope. And the groundbreaking ruling came in this past April, and there's so many experts in this room that could talk about it, but really what it found was that there was a violation of Article 8, the right to respect for private and family life, and then a breach of Article 6, right to a fair trial. So, it had these important holdings in it, but I think what it showed is that states have these obligations, and they are obligations that they cannot be ignored, and I hope that that's ringing loud and clear within the International Court of Justice this week. And it's also an important case because it's part of a global effort to change who is being heard and given space in the courtroom, and who's contributing to redefining who has power and how power is used. And what's happening here in The Hague is a part of this legal revolution, where the stories and demands of communities are shaping the law and determining what justice looks like. So, yeah, it's a pretty important one. So my last one is kind of the pessimism one, but also so important. It's a reflection that we need to be prepared for the backlash. So there's a chapter in the book that's titled "Defending the Defender's State Responsibilities to Respect Climate Justice, the Rule of Law, the Rights of Counsel in Climate Litigation Worldwide." There's a lot in that chapter about the risk to individuals, defenders, but I'm going to focus on one aspect that they bring up in it, and it's a particular egregious tactic known as SLAP suits, strategic lawsuits against public participation. And SLAPs are used by unscrupulous business actors to intimidate, silence, and bankrupt those who raise legitimate concerns. And Greenpeace International, we've faced all sorts of legal challenges in our time, but never so severe than at this moment. And I know we are the canaries in the coal mine, potentially, so we need to fight this. So let me tell you a little bit about it. Since 2016, we've been hit with 2 massive SLAP suits. I'm going to focus on one of those. This is a SLAP suit that was brought by a US energy company, Energy Transfer Partners. They are claiming that Greenpeace was behind the historic indigenous-led protests against the Dakota Access Pipeline. They are suing for over $300 million in damages, plus attorney's fees, plus punitive damages, so we're talking more than $300 million. This case is going to trial in next year, and one of the claims is that Greenpeace International had no role in the protests on the ground. We're a Dutch-based organization, and all we did was sign on to a letter with 500 others. So this case sends a signal to everyone else: if you sign on to a letter, you could face hundreds of millions of dollars in damages. And we want to make sure that this does not silence activism. So we're fighting day and night to win this case and ultimately prevail. But there's also optimism in SLAPs. So this is my promise, my last point. The optimism of SLAPs. There's also a movement of people who are working to get anti-SLAP protections into law. And so we see the EU directive. Greenpeace is relying on the EU directive to say that you cannot slap us in the Netherlands. So there is so much, and we're coming together and we're powering through, and I know that there's so many other things to discuss there, but I just want to say that was the first article that I've read in a book about climate law and responsibilities that had this in there. So thank you very much.
Thank you very much for your presentations. We have a game now, but we have a problem with the game. Everyone has their keychains? No? Okay.
I will hide them again.
Okay. There are 5 keychains that have a price on them, and the price is the book. So. So at least one of you have. If some of you have the keychain with a number and a signature in it, in the paper part of the keychain, then you win a prize!
I really wanted to work.
Good, big deal. So, our first winner, please. Who else has the winning keychains? Great! Congratulations, yes. Valentina, that was hiding.
We have 5 copies.
What's up? David Boyd, great! And who else?
Kind
No?
of cheating though.
We have another one without a winner.
Oh, for Great Business Australia, there's another one.
Quiz.
Okay.
A complicated legal question on climate
Someone tries to choose which one. I
No, yeah, a quiz. That's a
quiz.
Yeah.
A question.
Let's do a quiz to win the last.
Because they have the one there.
A legal question.
movie.
A rough one.
Okay, explain the outcome.
Okay. Who can describe the Court of Appeals decision in Shell? And why it is different than the...
No, you need to know that.
It has to be something like one or two. Like.
Okay, that's one. So one is on Shell. You have another.
That's a hard question. I was like, what's the capital of Chile?
When common but differentiated responsibilities was mentioned for the first time.
When it's
Common but differentiated responsibilities. First time that was mentioned in a treaty, in an instrument.
Before your time.
Who is the first?
Who was the first?
You were the first. Okay.
Rio?
Rio? Yes, Rio. You won! Thank you. Okay. Well, anyways, the book is open. It's open access. You have it there, and you can pass it to everyone that wants to see it because it's open access. And you have also the QR code in your keychains, so you can pass it via the keychains. And that's it. Now we have food and drinks. Thank you very much for attending this lunch.